Arguments this morning. That is case number 103559, State of Kansas versus Evelyn L. Wells.
Counsel, my name is Corey Call. I'm representing Evelyn Wells. We request 3 minutes for rebuttal, please.
3 minutes is granted.
Ms. Wells was convicted of 2 counts of rape, 1 count of sodomy, and 1 count of endangering a child. Raised several issues in the brief. The first issue is a prosecutorial misconduct claim, and I love to talk about prosecutorial misconduct claims, but the second issue in the brief is an alternative means issue. And unless the court had questions or wanted to discuss the first issue, I think the alternative means is a hot topic right now, and I think we could get into that. I'd prefer that. I talked with Mr. Maloney before argument, and last Friday, this court issued an opinion in State v. Brown, which clarified the landscape somewhat on what an alternative means is. He's read the case and has indicated he's prepared to talk about it. And I don't have a written 609 letter, but it's sort of the elephant in the room on alternative means if I can. So with the court's permission, even there's no 609, I would prefer to speak with it.
You may proceed.
Thank you. The issue goes back to State v. Wright, which is an alternative means issue. The jury was instructed on the sodomy count that oral contact or oral penetration of the female genitalia or oral contact of the male genitalia is sodomy. And that comes from a definitional section in
that definition, does that create an alternative means on the oral aspect of the sodomy?
You're referring to the first line, which is oral contact or oral penetration. Is that, and then because there's 2 ors in that sentence. The first is oral contact or oral penetration of the female genitalia, and then the second is oral contact of the male genitalia. And I would say post-Brown, this case on Friday, the oral contact or oral penetration would be an option within a means, I believe is the language that Brown used to distinguish situations that do not need a supersufficiency.
But it's just a matter of where we draw the line.
Right.
Now, aggravated criminal sodomy has oral, anal, bestiality, right?
That's correct.
Okay, so those are the 3 areas. And it depends on whether we consider options being male or female, or whether those are 2 separate crimes or intended to be 2 separate ways. To me, it feels more like an option because the oral versus the anal versus the bestiality are the 3 ways you commit the crime. So explain to me why the gender is a separate crime rather than just a option for committing the oral version of the offense. Do you understand what I'm asking?
I do understand, and there is line drawing here, and we're on the edge here. We're figuring this all out together, I think. And so there certainly is some sort of line, and I think I would agree with, if I understand your question, that the oral, anal, bestiality would be 3 different means that would be. And I think this is the same because the acts are so different. And what I go back to, I was thinking about this, and in this case, she was actually charged with oral sodomy, as she was convicted of here. She was also charged with anal sodomy. Those were 2 different counts. And it strikes me that they could have also charged, had there been evidence of that the child's, or that some female vagina was touched, they could have charged that as a separate count of sodomy, that because it's so different, it's a different manner of committing the crime, as opposed to you wouldn't charge oral contact and then charge in a different count oral penetration. Those are very similar ways of committing a type of element, whereas opposed to the talking about when you change the gender of the victim and you change the nature of the contact, that's an entirely different manner of committing sodomy.
Isn't that really your distinction, is it changes the victim in this case?
Right, yes,
Yeah,
yes.
if it had been oral contact or oral penetration of the female genitalia, it would have been the little 5-year-old victim.
That's right.
Instead, this was directed towards the forced oral contact by the victim of the male genitalia.
That's correct.
And that's two totally different things.
That's our argument, exactly, as opposed to the contact.
How do you distinguish that with the statutes that speak to submitted to or committed? Because that's really what we have here. We have the same victim. It's this little girl. And whether she was required to be the actor or the recipient of the action. And I think we have statutes that throw in there, committed or submitted to. And what I hear you say, that the commission, that active act, or the submission are so separate and so distinct as to be separate crimes.
I think that's correct. The only factually, I would add that in this factual situation, you also have the mother. There was testimony from the interview that the mother was an active participant in the rapes, and at trial, the daughter testified that the mother was not wearing any clothes during the situation. So you do have a situation where it is committed or submitted to, but you also have evidence could have been that she touched the mother, and that there was oral contact with the mother.
There was never any evidence or even suggestion of that, was there?
No, there was not. There was not.
So this is just hypothetical. Could have.
Well, I mean, the nature of the issue is such that we're necessarily dealing with scenarios where there's no evidence. If there was evidence, then I wouldn't have a right issue. There wouldn't be an alternative means. So yes, it's speculative, but that's the nature of the beast. One thing I just want to touch on, I think it was clear, but I want to touch on in Brown, one of the key factors was, or one of the factors the court would look at was whether it's a definitional statute as opposed to whether it's set out within the subsections. And this is certainly definitional. It's not set in the subsection, but the crime is sodomy, criminal sodomy or ag sodomy, and the definitional section is of sodomy. And as the court indicated, it has different criteria. So I think even though generally definitional, putting the different means within a definitional section could indicate that it's an option within a means, I think this is a different situation than the norm, because the definitional section essentially contains the different manners in which the overall crime sodomy can be committed. If there are no further questions on the alternative means, I'll jump over to the first issue, go back to the prosecutorial misconduct claim. The court, let me get the exact language, what the prosecutor said. This is on the rapes, and there were several incidents. The SW testified that this happened several times, and so it was a multiple acts situation. The court found that it needed to give a multiple acts instruction, and the state argued in its closing argument, if I could read I'll try and read the whole thing so as not to take it out of context. Instruction number 17, which is the multiple acts instruction, it's kind of referred to as the multiple act instruction. What it says is, in essence, if you read it, and if I'm misquoting here, it says, in essence, you all have to agree that these things are unanimous, that these things occurred on specific times. I don't have a date to give you. SW doesn't have a date to give you, but you must unanimously agree that it happened at least once as to this count, and then later on there's a separate rape count. You have to agree that it happened at least a second time. That's the paragraph that we take issue with. Now, the state notes that in the beginning, the state says you all have to agree that these things are unanimous, that these things occurred on specific times. That's a correct statement of the law. I think we can all agree on that. And I think we can all agree that at the end, when the prosecutor says you must unanimously agree that it happened at least once as to this count, and then later on there's a separate rape count, you have to agree that it happened at least a second time, that is not an accurate statement of the law. That tells the jury that as long as they all agree that she was raped once, that they can convict, notwithstanding the fact that they may agree on different times or different manners. And so the state argues that is overall a correct statement of the law. I guess if you have the state says it correctly and says it incorrectly, that they cancel each other out and it's correct. I think if you say it wrong, it's a misconduct. And I think that was a misstatement of the law.
If it's misconduct, where does the defense counsel correctly stated or summarized what the unanimity instruction requires, in that it requires that it occurred and it's the same incident? And then you have the instruction itself, which is basically self-explanatory that it has to be the same incident. Does that cure whatever error was made by the prosecutor?
I don't think so. I
I mean,
think
why not? Because why not? The jury's told to follow the instructions. What you have here is an inaccurate explanation of the instruction, but it is another interpretation, a correct interpretation is given by defense counsel, then you have the instruction itself.
Well, I think, first of all, I believe if we go through the Tosh factors, I think it would go into the third factor on the overwhelming evidence. It wouldn't comment on the
You
gross.
would say there's ill will here?
I would say there's ill will here. There are three factors, whether it was deliberate, whether it was repeated, and whether it was a violation of the court's orders. And it wasn't repeated. Once was enough for this statement, that didn't exist for ill will. But I think it was deliberate. This wasn't an off the cuff. This wasn't a rebuttal. It was towards the beginning of his closing statement, and the state acknowledges in the statement that he's summarizing, he's paraphrasing the statement. He knows what the statement says, and then says almost exactly the opposite. This is exactly. The argument he made is the exact reason we have the multiple acts instruction. It's because we're afraid that jurors would do this.
But didn't he start by saying, and you read it, if I'm misquoting here?
That's right. And clearly he wasn't quoting it at all. But the question is whether or not a jury would be, if they read the instruction, which it's a long instruction, but the end is that you must unanimously agree upon the same underlying act.
And my question has always been, how does that clarify it for the jury? In this circumstance, the act was oral sodomy. And why does that clear up the prosecutor's misstatement? How does that clarify for anyone? It doesn't say the same time and location. It says same underlying act, and the underlying act is sodomy.
Rape or rape. I think.
Rape.
Yeah. I think that's exactly right. And I think on the harmless error, it seems to me on the harmless error analysis, you have to go through a Voiles analysis, because this comment essentially negated the instruction. So it's as if the instruction was never again. So you do a Voiles analysis, and I'm out of time. May I finish this thought? Thank you. Under a Voiles analysis, I think the rape is stronger than the sodomy, because on the rape, you have a situation where the girl testified during her interview that the mother touched her vagina and that the man touched her vagina. And you have, at trial, she just testified that the man touched her vagina, and not Ms. Wells. So in that situation, I think you could have jurors that thought, okay, I'm going to believe her testimony that the mother touched her interview testimony, but I'm not even going to think about whether the mother encouraged this rape or not. I'm not going to think about that. And I suppose you have other jurors that say, well, she didn't say it at trial that the mother touched me, but I do believe that she encouraged it. And you have that kind of problem. And I guess I don't want to ignore your question. I wasn't ducking you. I think you have it said wrong and you have it said right. And what the judge said, I would agree with the court, that I'm not sure that really clarifies things. And so if you have it said wrong and you have it said right, I'm not sure that we can say beyond a reasonable doubt, the state can prove beyond a reasonable doubt, that it didn't make a difference. Because you have it both ways. And so I would think it doesn't play into the harmlessness there.
Counsel's out of time. Do we have any further questions? Thank you, counsel.
Thank you.
counsel. Assistant District Attorney Matt Maloney for the state. I know this court is aware of the facts, and I certainly don't intend to spend much time recapping them. I do think that it does bear mentioning that we need to remember that the victim in this case suffered unspeakable acts of sexual abuse by her mother and by Reginald Stafford. The abuse occurred over a lengthy period of time. It was, the charging document gave about an 11-month window. And because of that lengthy period and because of the victim's age, understandably, she was not able to provide specific dates in her testimony. And I think that leads into and is relevant in discussing issue 1, which is the misconduct claim. Because there were no definitive dates, there was a multiple acts instruction that was given. And that multiple acts instruction was a proper statement of the law, according to what the court has always indicated. The prosecutor summarized. He pointed the jury to that instruction, and he summarized it. And when I make misconduct arguments, one of the first things I always do is I ask this court to keep the statements of the prosecutor in context. And I appreciate the fact that counsel has cited and discussed the entirety of the prosecutor's comment in this case, because so often what we see is one sentence isolated and the rest of the statement ignored. So looking at the statement in context, I think it is first important to remember that the prosecutor did indicate by saying, in essence, that he was summarizing. He never claimed to be reciting the instruction verbatim. It's also important to remember that he told the jurors, read the instruction, and essentially indicated, if anything that I'm saying here doesn't seem to jive with the written language in the instruction, then look at the instruction. Go to that as your guide. He then summarized the instruction and at the very beginning said that the jurors would need to unanimously agree on specific times. And counsel has acknowledged today that that is a correct statement, an accurate statement of the law.
Can you move over to Justice Johnson's question, though, about how the instruction clears up the vagueness or the summary that the prosecutor
Certainly.
made?
And I will answer that. I would note that it was not something that counsel challenged in the brief, and so to some extent I haven't had more than about 3 minutes to think of that, but I do have an immediate reaction to that, which is that I think that is an accurate statement and it does clear it up. To me, when it says that the jurors must unanimously agree on the underlying act, I read that and interpret that to mean that underlying act includes such issues as date and time. I don't think that it would be so narrow as to indicate that the jurors could simply agree on, for instance, oral contact with the female genitalia, or be as limited as the court would believe that it might be. I think that when it says that the jurors have to unanimously agree on the same underlying act, that sufficiently conveys to the jurors that they need to agree on a specific act that occurred at a specific time and place. Again, this was not something that counsel or the defendant ever challenged, and so it certainly wasn't my focus in preparing for this argument or in writing my brief. But that's my initial impression of that instruction, is that it is a correct statement of the law and it does clarify for the jurors exactly what they need to agree on.
But accepting that this is something new from a legal standpoint, simply from a practical common sense standpoint, the same underlying act is more compelling if there's no question as to the act involved. Here we have, did mom touch the child? Did the gentleman involved touch her? Was there touching of the female? Was there touching of the male? In that context, underlying act becomes somewhat ambiguous. Wouldn't you agree? Rather than applying to a temporal, locational directive, it can also mean the particular means of committing the crime?
I guess my response to that would be that if the jurors found that instruction ambiguous, they certainly could have asked the court to clarify. And this was a jury that did ask a question. Specifically, they asked the court for the legal definition of abet. So this was a jury that had indicated and demonstrated that if they were uncertain about something included in the instructions, that they were willing to take the initiative and request
What if they were
clarification.
slam dunk certain that what it meant, and it meant they had to unanimously agree whether the young victim was touched or touched someone else? That was what they all thought it meant. That wouldn't be the meaning that was to be legally conveyed, would it?
Well, it wouldn't be, but I think at this point, then we'd be getting into the realm of we'd be speculating as to the basis behind the jury's verdict, which is obviously not something that we're allowed to do. I think we could throw out any number of hypotheticals in any direction and say that if this happened, then it would be improper.
And that's the whole point of the unanimity requirement, is that we don't speculate on whether different jurors convicted or had a different thought process, isn't it? I mean, that's the whole point of unanimity.
Sure. I guess I would just rely on the fact, again, that this was a pick instruction that has been improved many times, and that neither part, the defendant did not object to at trial, and in briefing this as a misconduct issue, did not argue that the instruction exacerbated whatever might have occurred based on the prosecutor's statement.
But that isn't what we're not talking about, the efficacy of the instruction generally. What we're talking about is, would you agree that all you have to decide is whether it happened once is a misstatement of the law?
I'm going to engage in semantics here. I'm going to disagree with what counsel said. Counsel argued that that was an inaccurate statement of the law. I would argue that it was accurate, but perhaps a little bit incomplete. It's accurate what he said, that the jurors would have to unanimously agree that it happened at least once. That's true. They do have to unanimously agree that it happened at least once. I think that perhaps it was a little bit was left unspoken, as far as not saying it has to have been on the same specific time. But he had already said that. He had already modified it by saying that the first time. And again, he further modified it by pointing them directly back to the instruction.
Well, that's my question. I understand your argument that any misdirection by the prosecutor's statement, you only have to find it happens once, could be clarified by other statements. But my question was, how can you rely on the instruction to clarify the misdirection? I don't see that. I see the clarification in what the prosecutor said, but I don't see the clarification or the cure in the instruction.
Well, again, I think that my reading in the instruction, and we might just have to agree to disagree, I think that my interpretation is that by telling them that they have to unanimously agree on the same underlying act, I think that that sufficiently conveys to them that there is a necessity that they agree on the same specific time and occasion and all the details surrounding the act upon which they're basing their verdict. I'd further point out, as I did in the brief, and I think perhaps it was Justice Rosen that asked a question about this, I do think that, again, the prosecutor couched this in terms of the instruction as it was written, and furthermore, the prosecutor, he indicated that this was a summary. It was to be a guide. And I don't know how we can find, or how this court could find, that such conduct would be gross or flagrant or an evidence of ill will if the prosecutor is acknowledging the instruction controls here. I'm human. I'm paraphrasing it here. I might say something that somewhat conflicts with what's in the written instruction. If I do, rely on that. And so I think when you get to the gross and flagrant, let alone the ill will part of this analysis, it would be difficult to see how it could be determined that the prosecutor's conduct met that portion of the test. The prosecutor, if the prosecutor wanted to mislead the jury and was doing something out of ill will, I don't think that his first thing to do would be to say, look at the instruction. Use that as your guide. Clearly, if he were wanting to misstate the law intentionally and show ill will, he would not point them directly to the correct law.
Counsel, will you have time to address alternative means?
Certainly, and thank you for leading me there. And counsel and I did talk, and we both agreed that the Brown opinion obviously was significant. And I would agree that the question really becomes then, is this an option within a mean, or is it an alternative means? And not surprisingly, our position is that the distinction that the defense is making here between male and female genitalia is an options within a means. And I agree with the position or the question that Justice Johnson asked counsel. I think that the statute presents the three means would be oral sodomy, anal sodomy, and bestiality. The remainder of the instruction, of the statute and the instruction, I would argue, create options within means. When you look at the statute, and I believe the Brown opinion discussed this, that sometimes one of your best guides in looking at whether something is an alternative means or an option within a mean, is look at how the legislature drafted the statute. And in this case, we see that the definitional instruction, which was based on the statute, sets forth sodomy, and it describes various things, but there are three parts that are separated by semicolons, and those would be the oral, anal, and bestiality sections. Within each of those means, there's obviously additional language, and in the case of the oral sodomy definition is where we see oral contact or oral penetration of the female genitalia or oral contact of the male genitalia. Those are not separated by semicolons. They're simply all included in the one definition of oral sodomy. And I would argue that, using the language of Brown, that is just a definition of a factual circumstance that would prove oral sodomy. I think also when you consider, and maybe this is more of a common sense argument, but I think it's also a legislative intent argument, I think that you look at the statute and it appears to me that the legislature is indicating sodomy are this is the three things that we're trying to prohibit here. This is what we're criminalizing: oral sodomy, anal sodomy, and bestiality. I would find it difficult to believe that within that the legislature was intending to create additional means dependent on whether it was the male or female genitalia. Certainly I don't think it matters to this victim whether it was contact with the female or the male genitalia. Either way, the damage to her is irreparable. She's a 5-year-old girl that was forced to engage in oral sodomy, regardless of whose genitalia was contacted in this situation. So our position is that, using the analysis in Brown, that whose genitalia was touched is simply a factual circumstance. It's an option within a mean, and does not create yet an additional alternative means within the oral sodomy mean.
But is that the touchstone, what it means to the victim? I thought it was what we're really looking at is what did the legislature intend the state to have to prove
Correct.
To convict this defendant.
And I bring that up because I think they dovetail in this situation. I think that the legislature obviously would be able to recognize that while oral sodomy and anal sodomy are two different things and are sufficiently different to characterize them perhaps as alternative means, I don't think that the legislature would intend that in this particular situation. Just like counsel himself acknowledged that he's not even arguing that oral contact or oral penetration would themselves be additional alternative means, because I think at some point we have to recognize that the conduct is sufficiently similar to characterize it as just one means. So based on that, I would argue that the Brown opinion does weigh in the state's favor. I certainly have briefed many other subtopics within the alternative means, and I don't mean to abandon those, but given the timing of this argument and when Brown was released, that was my intent, was to focus on how that opinion would come into play in this case. I would certainly even go a step further and ask this court to reconsider joining in with Justice Moritz on her opinion in the Brown decision. But even failing that, I would argue that that these were options within means, and that the state was not required to provide proof of both of those options within that mean. I see I'm out of time. I'd be happy to address any further questions, but absent that, we would just respectfully... Yes, Your Honor? I
do have. Was there a compelling reason to restrict cross-examination?
I would argue a very compelling reason, a couple of compelling reasons. First is that the question asked of the victim was the question asked something that the law has told us is not relevant as far as the state having to prove, which is any penetration is sufficient for rape. And so therefore the state didn't have to prove the depth of penetration, which is what counsel was wanting to question the victim.
So you can only cross-examine on the elements?
Well, and that's why I say that was just the first reason. The second reason, I think, is from a practical standpoint, as I argued in the brief. I do not conceive of a situation in which this victim would have been able to provide meaningful testimony to answer that question. I don't know how any victim, whether they're 5 or 35, in going through the trauma of a forcible rape, would be able to give a specific answer indicating this is the depth of the penetration. So the second response would be, I don't think that the victim would have been able to provide a meaningful, relevant answer. And the third reason...
Now, okay. I can understand that as being harmless, that it wouldn't have generated any information useful, but is that the touchstone for cross-examination?
Well, I think if there's a question that can't possibly lead to any meaningful or relevant information, then I think that there's a relevancy issue here. If counsel asks a question where there's no realistic way...
And if she testified, yeah, he went in real deep, then that would have allowed the defendant to make the argument that there was no physical manifestations here, do we believe her testimony? As abhorrent as it is, what we're talking about is a confrontation right, and confrontation right includes the right to test credibility through the crucible of cross-examination. And when you start limiting that, then we have some constitutional implications, do we not?
We would, but he was allowed to pursue that not only through cross-examining. He was allowed to ask the victim, did it hurt a lot when he penetrated? So he was able to explore it to some extent with the victim, with just one limited exception. But he presented that theory in full through cross-examining the medical experts, and that was going to be the third portion of my response, is that he explored this issue, the specific issue about the likelihood of injuries and whether the victim was more or less likely to suffer visible injuries with the nurse. And her testimony... Was her testimony prior to the victim's? Chronologically, I think I could look that up for you. I don't remember off the top of my head.
That's all right.
But what was telling about that is that she testified that not only is it possible for the victim not to have suffered injuries in a situation like this, but that it was actually likely that the victim would not, especially given the fact that the victim was not examined until approximately 4 months after the last episode of sexual abuse occurred. Your Honor, the victim did, I believe, testify before Nurse Gilhoppel, is what my notes indicate. But the defendant went into this theory of defense in full. There was just one very specific question, and Your Honor, I appreciate your question that there's obviously a right to confrontation, But I do think that allowing this type of question, I think, would render meaningless to some extent the law that any penetration is sufficient. And I think that it would open a door that would lead to a lot of things that, even given the right to confrontation, we would not want to see in criminal trials. I think that you're looking at a victim that's 4 or 5 years old, maybe a little bit older than that at the time of trial. And do we really want to have trials where a defense attorney can get up there and ask questions like this, and then if they're able to provide any plausible explanation and say, well, in a theoretical world, maybe this could help my theory of defense with respect to injuries, even though we've already heard from the medical expert that injuries are not likely to happen in this situation, and that I wouldn't have seen them anyways because the exam was conducted several months after the last episode of abuse occurred here. So our position is that the court properly excluded that. If this court disagrees, then we would rely on harmless error analysis, but I don't think that the court needs to get there because I do think that the court properly limited the defense.
I suppose I have a query. Is the opposite true? If there were injuries, is that relevant? If injuries are not a part of the case or not a part of the consequence of being abused in this fashion? I mean, wouldn't you have put on evidence if there were injuries?
I think... Honestly, I'd have to say yes. I think that the state, in cases where there is physical injury to the victim, I think that's clearly something that the state generally will have an interest in putting before the jury. And I understand your question, Your Honor, but I think that it doesn't change the fact that the lack of injuries is not something, or in this question, the depth of penetration is not something that can in any way negate a finding of guilt. It simply is not an element, and again, in this situation, it's not something that was likely to have been present regardless. So for those reasons, we would respectfully, and I would submit the other issues on the brief, we would respectfully request that this court affirm the defendant's conviction and sentence.
Thank you, counsel. You had reserved 3 minutes for rebuttal.
Thank you. I was able to, pardon me, with regards to the court's question about the defense counsel's response on the multiple acts instruction and whether that clarified things for the jury. The paragraph I found is in volume 16 on page 93. That was where I found the response, and that was Mr. Stafford's attorney who was talking to the jury. What he said was, and I think it's instruction 17 that Mr. Bennett talked to you about, you've got to agree that it occurred and it's the same incident, not that she was raped twice during that time period, when, where, how. And so I think that, first of all, that undercuts the state's argument that everybody at the trial understood what the prosecutor was saying and had no problem with it. Mr. Mank had a problem with it. But also, the language that you've got to agree that it occurred, it's the same incident. Again, this is Mr. Stafford talking, and what he's concerned about is different time periods that it happened, because the allegation was that he touched her. There's an additional element as far as the multiple acts that we talked about, sort of the harmlessness as far as whether the mother encouraged Mr. Stafford or whether she actually participated, that the jury also has to agree with. And that's not addressed in, you've got to agree that it occurred and it's the same incident. And so I would say that paragraph does not adequately cure the state's misconduct. That was what I had.
We have any further questions of counsel?
The way I understood opposing counsel with regard to the cross-examination sort of indicated that it was so marginally relevant, given the medical testimony that you wouldn't expect to see injury, that it was properly excluded. How would you address that?
First, I would say, I don't know if this is the point, but I would agree with that. That's a harmlessness analysis. It's still relevant. It still has a tendency to prove.
Well, no. All relevant evidence is admissible. The corollary is that if it's not relevant, it's not admissible. And the argument that I took away was everyone testified that 4 months after the incident, you wouldn't really expect to see any injury. So how can you make potential injury? Why is the question relevant?
Because the fact that it's not likely doesn't mean that it doesn't exist. And we know that there are cases where physical damage does occur. And it may not happen in all cases, and it may not be something that an examiner would expect, but it does happen, and there can be scarring even 4 months down the line. And so, and this was the defense wanted to convince the jury of that. Convince the jury that may not be expected, but this is the type of case when it could, and that's only going to occur if there is a depth of penetration.
Any further questions of counsel?
Can you recall anywhere in the record where the statements of the victim would have linked to the question about penetration? In other words, would there be some disagreement or some statement about penetration that a question at trial could be used to attack credibility?
No. If I understand your question, like in the initial interview, did she talk about penetration?
Yes. Anywhere before trial, did she talk about penetration?
I'm not aware of that. I don't believe that was one of the questions that was asked. I don't remember that testimony. So I would say no, but I'm not definitive on it.
All right. Thank you, counsel.
Thank you.
I wanted to commend both counsel for their reading of Brown when it was released, and not only being able to answer our questions today, but also being able to weave Brown into your arguments this morning. As always, we appreciate all your arguments today, and the court will take this matter under advisement. This time the court is in recess for 15 minutes. both